Hello, everyone. Welcome to Working Mothers, What to Expect from Your Employer When You're Expecting, a webinar hosted by the U.S. Department of Labor's Wage and Hour Division, the Women's Bureau, and the U.S. Equal Employment Opportunity Commission. If you prefer to listen to this presentation in Spanish, please join the interpreter line by calling 800-369-1742 and entering the PIN 382-3580#.
Si prefiere escuchar esta presentación en español, únase a la línea de interpretación llamando al 800-369-1742 e ingrese el PIN 3823580, seguido por el símbolo del número. Sus preguntas se pueden enviar en español en cualquier momento utilizando la función de preguntas y respuestas en su pantalla. Puede encontrar esta misma información en los anuncios del evento.
My name is Udochi Onwubiko, Senior Policy Advisor at the Wage and Hour Division. I will serve as host for today's event. First, some logistics before we begin. You can also find these details in the announcements on the right of your screen. First, you can enable real-time captions by selecting the closed captions or CC icon on the bottom right of your screen. You can toggle the feature on and off. Second, this event is being recorded. All attendees are in listen-only mode. Before we begin the presentation, we are pleased to have brief welcoming remarks from our agency's leadership.
Welcome, everyone. Thank you for joining us here today for this important multi-agency effort, Working Mothers, What to Expect from Your Employer When You're Expecting. I really want to thank the Equal Employment Opportunity Commission and the Women's Bureau for their critical role in making this event a success. As we commemorate National Breastfeeding Awareness Month, we recognize the vital importance of maternal health to our families, our communities, and our future. And of course, new mothers face unique challenges to their health, to their well-being, and to their financial and economic lives. The well-being of new and expected mothers deserves our collective attention and our diligent protection. Sadly, significant disparities exist in our country that have a negative impact on their access to services and health outcomes. We know that women of color have almost 3 times the risk of negative health consequences related to pregnancy as non-Hispanic white women. We know that a full 2/3 of all pregnancy-related deaths are avoidable. We know that chronic conditions such as high blood pressure and diabetes can be managed throughout pregnancy to ensure the health of mother and child. We know that mothers and families struggling with postpartum depression benefit significantly from mental health services. And we know the benefits for mothers who choose to breastfeed are many, from bonding to increased immunity, to long-term benefits such as decreased rates of obesity and asthma throughout childhood. And we know how to take better care of mothers and babies, and we have a moral obligation to do just that. We also know that over 57% of all women in the US are active in the nation's workforce. It is imperative that women know and are able to assert the protections afforded to them to protect their health and well-being of themselves and their families. As you will learn more about today, our federal laws provide workplace protections throughout the phases of motherhood. For expectant moms, federal law protects against pregnancy discrimination in the workplace and allows eligible expectant mothers to take leave from work to receive proper prenatal care and receive necessary medical care if certain risks are presented during the pregnancy. For moms preparing to give birth or welcome an adopted child, federal law allows eligible workers to take leave to bond with their infant or adopted child within the first year of the birth or adoption. And when new mothers are ready to return to work, federal law assures that mothers can return to their jobs after leave and are protected against discrimination and retaliation, and that nursing mothers have a clean and private space to express breast milk while at work. We know that these protections are critical for balancing employment and motherhood, and we are here to help. And this is just the beginning of a series of events planned to share information about the rights of new and expected mothers. Our goal is to empower expectant and new mothers with information and to assure them that we will use every tool at our disposal to ensure that their rights are protected. We will continue to elevate the importance of maternal health to the families and the future of our nation. Thank you for being here and welcome.
Hi, my name is Wendy Chun-Hoon and I direct the Women's Bureau at the United States Department of Labor. We're thrilled to join the Wage and Hour Division and the Equal Employment Opportunity Commission to kick off this series of webinars on workplace protections for new and expectant parents. The Women's Bureau is the only federal agency authorized by Congress to represent the needs and interests of working women. That means we want every workplace to be one where women feel safe and valued. Building and sustaining equitable workplaces for pregnant, nursing, and postpartum workers is essential. With our reproductive rights in jeopardy, an ongoing childcare crisis, and the lack of national paid family medical leave and sick time means that women are left making difficult decisions about their family's well-being and their own ability to continue working. All workers should be able to care for their health and their families while continuing to be able to safely earn a family-sustaining income. Today, you'll learn more about what rights you have in the workplace. We must ensure that all pregnant and nursing workers know their rights and are empowered to assert them in their workplaces. I encourage you to visit our website to access resources about employment protection for workers who are pregnant or nursing, including our federal and state employment protections map and Women's Bureau and Wage and Hours recently released Nursing Parents Workplace Protections Flyer, which is available in English and Spanish. We at the Women's Bureau will continue to advocate for and raise awareness about equity for all pregnant and nursing workers in our country. We are so excited that you're joining us today. Please follow us on Twitter and sign up for our newsletter to get regular updates. We'd like to hear from you. Thank you.
Greetings on behalf of the U.S. Equal Employment Opportunity Commission. First, I'd like to thank the Women's Bureau and the Wage and Hour Division for inviting me and others with our team at the EEOC to participate in this important discussion. I look forward to continuing to work with them on this very timely topic. Caregivers employed outside the home are a vital part of our nation's workforce. Despite that, we have witnessed the COVID-19 pandemic's disproportionate impact on working mothers and other caregivers compared to other workers. The pandemic also underscored how the work caregivers do both at home and in the workplace is in all of our interests. At the EEOC, we enforce the federal laws against employment discrimination, including Title VII of the Civil Rights Act of 1964, which prohibits sex discrimination, the Pregnancy Discrimination Act, which made clear that sex discrimination includes discrimination based on pregnancy and childbirth, and the Americans with Disabilities Act, which provides important protections for those who experience medical conditions related to their pregnancies. Together, these laws provide significant workplace protections for workers before they become pregnant, during their pregnancies, and afterwards. Too often, parents, and especially new parents, don't know how these laws apply to their circumstances. That's why the EEOC engages in significant outreach and enforcement efforts, together with other federal agencies, to protect the rights of workers who are pregnant or caregivers. The EEOC is committed to educating the employers and the public about these civil rights protections. In 2015, EEOC issued enforcement guidance on pregnancy discrimination and related issues. And this spring, we issued new technical assistance on the COVID-19 pandemic and caregiver discrimination to explain how discriminating against employees with caregiving responsibilities of any sex may violate the law when based on a protected characteristic like race or sex. And through our enforcement efforts, we have obtained substantial relief for pregnant workers who have faced discrimination. For example, in one matter the Commission settled recently, a leasing company terminated a newly hired woman once it became clear that she was pregnant, even though she had favorable performance reviews. The company replaced her the very next day with a non-pregnant employee. In addition to providing $85,000 in monetary relief to the worker, the employer is revising its policies to provide stronger complaint processes and in pregnancy-related accommodations. For working mothers and caregivers, knowing your rights and how to enforce them gives you the power to ensure that those rights are respected in the workplace. And we're delighted to be part of this effort.
Here is our disclaimer. Please contact the Wage and Hour Division with any questions. Over the course of this presentation, we will be focusing on the workplace protections available during your pregnancy, when it's time to take time off from work for birth or to welcome a new child, and when it's time to return to work and take breaks to pump. We will also talk about how you can take action if you think your rights are being violated or you are being retaliated against. We will also have some time at the end to take questions. Questions can be submitted at any time using the Q&A feature on the right of your screen. You can also type your questions in Spanish using the Q&A feature. We will be gathering these questions and respond to them during the Q&A portion at the end. Without further ado, I will turn it over to Jennifer.
Hello, my name is Jennifer Carlo, and I'm a lead systemic investigator for the U.S. Equal Employment Opportunity Commission. I'm going to start with questions you may have about your legal protections during your pregnancy. If your employer knows that you are pregnant or may become pregnant, can you be fired? Well, the short answer is no. It is unlawful for you to be fired because you may become pregnant, because you are pregnant, or because you ask for light duty work, leave, or other benefits because of your pregnancy. Title VII of the Civil Rights Act of 1964 prohibits discrimination based on sex in employment. The Pregnancy Discrimination Act, or PDA, is an amendment to Title VII, clarifying that discrimination on the basis of pregnancy, childbirth, or related medical conditions constitutes unlawful sex discrimination under Title VII. It requires that employers treat pregnant workers the same as non-pregnant applicants or employees who are similar in their ability or inability to work. Title VII and the PDA prohibit discrimination with respect to all aspects of employment, including pay, job assignments, hiring, firing, promotions, training, and fringe benefits such as leave and health insurance. I want to clarify that while federal law does not explicitly prohibit employers from asking you whether you are or intend to become pregnant, because such questions may indicate a possible intent to discriminate based on pregnancy, we recommend that employers avoid these type of questions. What if you are being harassed because of pregnancy or a pregnancy-related medical condition? The laws enforced by the EEOC protect you from being harassed at work because of pregnancy or pregnancy-related medical conditions. Examples of harassment can be unwelcome or offensive jokes or name-calling, ridicule, insults, intimidation, threats, or even physical assaults based on pregnancy or a related condition. For example, a pregnant firefighter might be harassed by her male coworkers because they believe they cannot rely on her in a fire based on her pregnancy. And they begin to make repeated offensive comments to the effect of, "Oh, not only is she a woman, but now she's pregnant." Or in another example, a supervisor that is constantly telling a pregnant employee, "You should really stop working and take care of yourself and your baby." This type of conduct may constitute unlawful harassment based on pregnancy. So what if you're having difficulty doing your job because of pregnancy or a medical condition related to your pregnancy? Employers must treat workers temporarily unable to perform their jobs due to pregnancy, childbirth, or related medical conditions the same as any other temporary disabled individual similar in their ability or inability to work. For example, The employer may have to provide light duty, an alternate work assignment, disability leave, or unpaid leave to pregnant employees if it does so for other temporarily disabled employees. So let's say your job occasionally requires you to lift up to 50 pounds. And as your pregnancy progresses, your doctor gives you a restriction of no lifting over 40 pounds. Other than that once in a while lifting on your job, you can do everything else the job requires. If your employer honors similar types of restrictions for non-pregnancy related temporary disabilities, the employer should treat restrictions based on pregnancy in the same manner. Pregnancy in and of itself is not a disability under the Americans with Disabilities Act, which we also call the ADA. So if you do not have a right to an accommodation under that law simply because you're pregnant, but you may have a right to accommodations under some state or local laws. Some impairments resulting from pregnancy, such as gestational diabetes or preeclampsia, may qualify as disabilities under the ADA. Whether or not such an impairment is covered by the ADA is determined on a case-by-case basis. If it is covered, you may have the right to a reasonable accommodation. So I've been using that word a lot, reasonable accommodation, and what does that mean? A reasonable accommodation is a change in the workplace or in the way things are customarily done that enables you to perform the essential functions of your job, absent an undue hardship. Well, what do we mean by an undue hardship? An undue hardship is a term defined as a significant difficulty or expense to the employer. What if there is no way that you can do your regular job even with an accommodation? If you are unable to do your regular job, even with an accommodation, you may be eligible for light duty, a temporary alternate work assignment, or even leave if necessary. The employer does not have to create a position for you, but if it offers light duty, temporary assignments, or leave to employees for reasons not related to pregnancy, it must treat pregnant employees in the same manner. For example, if an employer reserves light duty work for work-related injuries only, that policy could be problematic. Policies that deny light duty based on pregnancy will be assessed in terms of the burdens they place on pregnant workers and the employer's justification for the policy. One way a pregnant employee could demonstrate a significant burden is to show that the employer accommodates a large percentage of non-pregnant employees with limitations due to work-related injuries under its policy, while denying accommodations to a large percentage of pregnant employees. As we discussed earlier, if you are unable to do your regular job because of a pregnancy-related disability that's covered under the Americans with Disabilities Act, you have the right to request a reasonable accommodation, such as light duty, a temporary assignment, or leave. What if you can't work at all because of your pregnancy? As we mentioned before, employers must treat workers temporarily unable to perform their jobs due to pregnancy, childbirth, or a related medical condition, the same as any other temporarily disabled employees who are similar in their ability or inability to work. So if your employer grants leave for other temporary impairments not related to pregnancy, like an illness or sprained ankle, it should offer the same to pregnant employees. You also may be eligible for federally protected leave under the Family Medical Leave Act. We will go into the protections under this law in a little more detail later on in our presentation. You might be eligible for some state-specific leave protections, which vary based on the state you live in. Or if you develop a pregnancy-related disability covered under the Americans with Disabilities Act, you may be entitled to leave as an accommodation under the ADA. On the opposite end of the spectrum, but still related to leave, an employer may not force an employee to take leave because they are or have been pregnant, as long as they are able to perform their job. Forcing an employee to go out on leave violates the Pregnancy Discrimination Act, even if the employer believes it is acting in the employee's best interest. Likewise, if an employee has been absent from work as a result of a pregnancy-related condition and then recovers, an employer may not require the employee to remain on leave until the baby's birth, nor may the employer prohibit an employee from returning to work for a certain length of time after childbirth. So how do you know if you're protected against pregnancy discrimination and harassment under Title VII? You are protected under Title VII if you work for a private employer, state, or local government. And your employer must have at least 15 or more employees. If it's a close call, the EEOC has a formula to count employees. For example, say during the busy season, your employer might have 30 employees, but during the off-season, it may only regularly employ 10 people. The EEOC determines if it has jurisdiction if the employer has 15 or more employees for each working day in each of 20 or more calendar weeks in the same calendar year as, or in the calendar year prior to, when the alleged discrimination occurred. The weeks do not have to be consecutive. Your charge must also be timely filed, meaning within 180 days or 300 days, depending on the state where the employer is located. In many states, there is a state or local Fair Employment Practice Agency, which we refer to as a FEPA, that enforces similar laws to the EEOC on a state or local level. In states where there is a FEPA, the EEOC often has a work-sharing agreement with the FEPA, which means that you can pick where you want to file, and you are considered duly filed with both agencies. It also extends your deadline to file a charge from 180 days to 300 days. FEPAs may have different jurisdictional requirements. You need to check with the FEPA in your area for that information. Federal employees are also protected under Title VII, but the process for filing a complaint is different. So please refer to our website, www.eeoc.gov, for details. How do you talk to your employer about needing an accommodation, light duty, or leave because of your pregnancy? Start by checking your employee handbook, your intranet site, or human resources. Many larger employers will already have a policy in place for you to follow. In a very large organization, they might even have a specific department established to handle your request, like disability leave services or leave of absence office. Others may just say go to human resources. Start by following your employer's policy. If you can't find an applicable policy, or if you work for a smaller employer, talk to your manager and let them know what you need. Once you make your request, your employer may ask you for medical documentation to support your request, or they may ask you to fill out some paperwork. Keep in mind that state, local, and federal law represents the bare minimum employers must do. I often use the example of minimum wage. An employer must pay at least minimum wage, but it can pay employees more. Consider local, state, and federal laws the floor, not the ceiling. Letting your employer know what you need is the first step, and good communication goes a long way. Ideally, your employer will work with you to keep you safe and keep you working. Now we're going to hear from Trini about what to do when you have to take leave from work.
Thank you, Jennifer. Good afternoon. I am Trini Nahara Murguia. I am the Community Outreach and Resource Planning Specialist for the Wage and Hour Division. So you're pregnant. What rights do you have to take leave from work? The Family and Medical Leave Act, or the FMLA, allows eligible employees to take unpaid, job-protected leave for certain qualifying reasons. Among other qualifying reasons for leave, eligible employees may take up to 12 work weeks or of FMLA leave in a 12-month period to care for a spouse, parent, or child with a serious health condition, or for their own serious health condition. A serious health condition includes any period of incapacity due to pregnancy, for example, severe morning sickness, or for prenatal care. It does not require a doctor's visit for each absence. We will also go over what workers are eligible for FMLA leave later. Can a worker take leave for their same-sex spouse's pregnancy? Under the FMLA, the definition of spouse is a husband or wife as defined or recognized in the state where the employee was married and includes individuals in a same-sex marriage or common law marriage. Spouse also includes a husband or wife in a marriage that was entered into outside of the United States if the marriage could have been entered into in at least one state. You may use FMLA leave for the care of a spouse that is unable to work, attend school, or perform other regular daily activities because of pregnancy or for prenatal care. You may also take FMLA leave to care for your spouse who is recovering from childbirth. The FMLA does not, however, cover leave for the care of a partner who is your registered domestic partner or civil union partner if you are not legally married or common law married. Next, we'll talk about questions you may have about your legal protections when it's time to take time off for the birth or placement of your child. You have a new child. What rights do you have to take leave from work? Parents are entitled to FMLA leave for the birth or placement of a child and or to be with the child after the birth or placement, which is referred to as bonding time. Leave must be completed by the end of the 12-month period beginning on the date of the birth or placement. Employees may take FMLA leave before the birth, placement for foster care or adoption, for example, to attend counseling sessions, appear in court, consult with the attorney or doctor representing the birth parent, submit to a physical examination, or travel to another country to complete an adoption. Can you take FMLA leave for the birth of your partner's new child? Anyone who is a parent to a child can take FMLA leave for the child's birth, placement, or care. If you are eligible, you may use FMLA leave for the birth of a child and to bond with a child who is your biological, adopted, foster child, stepchild, or legal ward. You can also take leave on the basis of loco parentis relationship with a child. This means you're helping to raise and support a child even if you do not have a biological or legal relationship to the child. Although no legal or biological relationship is necessary, grandparents or other relatives, such as siblings, may stand in loco parentis to a child under the FMLA as long as the relative satisfies the in loco parentis requirements. Men and women have an equal right to FMLA leave for the birth, placement, or care of a child. You do not have to be married to take FMLA leave for the birth of your child or for the placement of your child for adoption or foster care. What happens to your health insurance and other benefits while you are on leave? Your employer must continue your group health plan coverage with the same benefit coverage as if you were not on leave. An employer is not required to provide group health plan benefits if it does not normally do so. For example, if the family member coverage is provided to an employee, the family member coverage must be maintained during the FMLA leave. Your rights to benefits other than group health benefits during your FMLA leave is determined by the employer's established policy for providing such benefits when the employee is on other forms of leave. Any benefits that would be maintained while the employee is on other forms of leave must be maintained while the employee is on FMLA leave. An employee may choose not to retain group health plan coverage during the FMLA leave, but the employer is still obligated to restore the employee to the same benefits upon return from FMLA leave. How much FMLA leave is available to you for pregnancy, birth, placement, and bonding? Eligible employees may take up to 12 work weeks of FMLA leave for family and medical reasons. These reasons include the birth or placement of a child for adoption or foster care, and for bonding with a child, to take care or spouse, son, daughter, or a parent with a serious health condition, including pregnancy, and for the employee's own serious health condition, including pregnancy. Here are some examples. You can take FMLA leave if you're unable to work due to pregnancy because you have severe morning sickness, or are confined to the bed rest due to a complication. You can take FMLA leave if you're caring for your family member who is unable to work, go to school, or do other regular daily activities due to pregnancy. You can take FMLA leave for your own or a family member's prenatal care, or you can take FMLA leave for your own or a family member's recovery from childbirth after hospitalization. You can also take FMLA leave for birth or placement of a child for adoption or foster care, including bonding time. Spouses who work for the same employer are limited to a combined total of 12 weeks of leave when leave is for birth, placement, and bonding. The limit on spouses working for the same employer does not apply to leave for pregnancy-related reasons or recovery from childbirth. The limit also does not apply to the care of a child with a serious health condition. Will you be paid during your FMLA leave? The FMLA does not require your employer to pay you for your time off. The FMLA does require that if your employer already provides paid time off, like paid vacation or paid sick leave, benefits, etc., then your employer may require you to use paid time off, vacation, sick leave, etc. during your FMLA leave, or you may choose to use the PTO, vacation, or sick leave, etc. your employer provides during your FMLA leave. Also, if you qualify for paid family and medical leave, parental leave, or disability leave under state law while you are on FMLA leave, your state paid leave benefit may be paid at the same time you are on FMLA leave. The FMLA does not allow you to save your FMLA leave for use after you have exhausted your other leave benefits. As soon as you are eligible for FMLA leave and you have a qualifying reason for FMLA leave, your employer must follow the requirements of the FMLA. How do you know if you are eligible for FMLA leave? First, you must work for a covered employer, which means the provisions of the FMLA apply to that employer. Covered employers under the FMLA include private employers who employ 50 or more employees in a 20 or more work weeks in the current calendar year or previous calendar year. Public agencies, including federal, state, and local government employers, are covered regardless of the number of employees. And public or private elementary and secondary schools are also covered regardless of the number of employees. How do you know if you are eligible for FMLA leave continued? If you work for a covered employer, you also must meet certain criteria. First, you must have worked for that employer for at least 12 months. The 12 months do not have to be consecutive. Second, you must have worked for the employer for at least 1,250 hours in the last 12 months prior to the start of the FMLA leave. To determine if an employee has worked 1,250 hours in the 12 months prior to the start of the FMLA leave, generally the actual hours worked, as defined by the Fair Labor Standards Act, are counted. If an employee has worked an average of more than 24 hours a week during the 12 months period before the leave starts, the employee will generally meet the hours worked eligibility test. Please note that there are special eligibility rules that apply to airline flight crew employees. For FMLA purposes, an airline flight crew employee is an airline flight crew member or flight attendant. Lastly, your employer must have 50 or more employees within 75 miles of your work site. For employees who telework, a worker's home is not a work site. The work site is the location where the employee reports to and from which assignments are made. What do you have to tell your employer to request FMLA leave? Both you and your employer have responsibilities for notifying the other when FMLA leave is being used. You must provide your employer with the appropriate notice of need for leave. Your employer must notify you if you are eligible for FMLA leave within 5 business days of your first leave request. give you a notice in writing of your rights and responsibilities under the FMLA, and let you know in writing if your leave is designated as FMLA qualifying. What you must do. You must follow your employer's leave request policies. Your employer may require you to comply with the employer's usual and customary notice and procedural requirements for requesting leave absent unusual circumstances. You must provide the employer at least 30 days notice for leave that is foreseeable. When leave is foreseeable, but 30 days notice is not possible, notice must be given as soon as possible and practical. Generally, notice should be given either the same day or the next business day. Notice for unforeseeable leave should be provided as soon as possible and practical under the facts and circumstances of the particular case. You must provide at least verbal notice sufficient to make the employer aware that the employee needs leave for an FMLA qualifying reason, and the anticipated timing and duration of the leave. If you are seeking leave for the first time for an FMLA qualifying reason, you need not expressly mention the FMLA. However, when you seek leave due to an FMLA qualifying reason for which the employer has previously provided FMLA protected leave, you must specifically reference either the qualifying reason for the leave or the need for FMLA leave. In all cases, the employer should inquire further if it is necessary to have more information. What your employer must do. When you request FMLA leave or your employer becomes aware that your leave may be for an FMLA qualifying reason, your employer must notify you of your eligibility status within 5 business days, absent extenuating circumstances. Your employer is also required to inform you of your rights and responsibilities regarding the use of FMLA leave. All covered employers are required to post a notice about the FMLA where it is readily able to be seen by employees. Each time your employer is required to provide an eligibility notice, your employer must also provide notice of your specific rights and responsibilities. When your employer has sufficient information to determine that the leave is for an FMLA qualifying reason, your employer must notify you whether the leave will be designated and counted as FMLA within 5 business days, absent extenuating circumstances. Do you have to give medical information to your employer to take FMLA leave? Your employer may require that your leave due to your own serious health condition or to care for your covered family member with a serious health condition be supported by a certification from your or your family member's health care provider. It is the employee's responsibility to find a healthcare provider who will provide complete certification. Healthcare provider generally includes doctors of medicine or osteopathy, clinical psychiatrist, podiatrist, dentist, optometrist, chiropractors with specific limitations, nurse practitioners, physician assistants, and any healthcare provider accepted by the employer or group health plan to substantiate a claim for benefits. The employee must provide the certification within 15 calendar days after the employer's request, unless it is not possible and practical to do so despite the employee's diligent, good faith efforts. The employee must pay for the cost of the medical certification if required by the employer. Your employer may not request a medical certification for FMLA leave for you to bond with a healthy newborn child or a healthy child placed for adoption or foster care. However, employers may require employees to provide reasonable documentation of a family relationship. To satisfy this requirement, you may provide your employer with a simple written statement or provide your employer with a copy of an official document such as your child's birth certificate or a court document for review and to be returned to you. Next, we'll talk about questions you may have about your legal protections when it's time to return to work. What happens when you are ready to go back to work? Upon return from FMLA leave, you must be restored to the same job or to an equivalent job. Equivalent job means a job that is virtually identical to the original job in terms of pay, benefits, and other employment terms and conditions. However, you are not guaranteed the actual job held prior to the leave. Upon return from FMLA leave, you remain entitled to all benefits accrued at the time the FMLA leave began. For example, paid leave to the extent not used during FMLA leave. You may, but are not entitled to, accrue benefits while out on leave. Now we are going to hear from Jennifer about what happens if your employer treats you differently when you return to work.
Thank you, Trini. What happens if your employer treats you differently when you return to work? It is unlawful for employers to base employment decisions on gender stereotypes, even if those decisions are well-intended. For example, employers may not decline to assign female caregivers demanding or high-profile projects or shifts that increase employees' advancement potential but require overtime or travel, or reassign such projects from female caregivers based on the employer's assumptions that such actions will make it easier for female employees to juggle work and personal obligations. However, if employees with caregiving responsibilities request work assignments that have a predictable schedule or that do not require extra hours or travel, employers may grant such requests at their discretion as long as they do so in a non-discriminatory manner. Now we're going to hear from Trini about continuing to pump breast milk after returning to work.
Thank you, Jennifer. If you are breastfeeding your baby, how can you continue to pump breast milk when you go back to work? Under the Fair Labor Standards Act, or FLSA, eligible nursing employees have the right to a reasonable break time to express breast milk and a place other than a bathroom that may be used to express milk. This right is available for up to 1 year after the child's birth. Workers who telework are eligible to take pump breaks under the FLSA on the same basis as other workers. How often can you take pump breaks? How much time do you have for your breaks? Employers are required to provide a reasonable break time each time you have a need to express milk. Nursing mothers produce milk on a constant basis. In order to maintain a milk supply, a mother needs to nurse or pump as frequently as the baby usually nurses. This means a nursing mother would likely need a break to express milk 2 to 3 times during an 8-hour shift, with more breaks required for longer shifts. Some factors affecting the frequency of breaks needed include the age of the baby, whether the baby is eating solid foods, as younger babies may nurse more often, and the baby's normal daily schedule. How long is a reasonable time for breaks? In some cases, it might take about 15 to 20 minutes to express breast milk, but other factors could add to this time, such as time it takes to walk to and from the lactation space and the wait, if any, to use the space. Whether employee has to retrieve pump and supplies from another location, the efficiency of the pump used to express milk, whether there is a sink and running water nearby to clean and pump attachments, time it takes to store milk in a refrigerator or personal cooler. Where can you pump during your breaks? The law states that an employer shall provide a place other than a bathroom, shielded from view, free from intrusion from coworkers and the public, that may be used by an employee to express breast milk. What is meant by shielded from view? This could be walls, partitions, cubicles, etc. Any windows would need to be covered. What about free from intrusion? This could be a room where you could lock the door or have a sign on the door indicating space is in use. The space should also be free of security cameras and computer cameras. What is a functional space? There must be a space for the nursing mother to sit and a flat surface other than the floor on which to place the pump. Ideally, there should be access to electricity to plug in an electric pump. While employers are not required to provide refrigeration, employers must also allow nursing employees to bring a pump and an insulated food container for storing the expressed milk at work and must provide a place where these items can be stored. The law says specifically that bathrooms are not permissible. Does your employer have to create a permanent space for you to pump breast milk at work? Where a room is not available, space may be temporarily made available or converted into a space for expressing milk. Your employer does not have the responsibility of maintaining a permanent, dedicated space for nursing employees to take breaks if there are no employees who need one. Spaces normally used for other purposes, such as a manager's office or storage space, may be sufficient if it is made available when needed, is functional, and is shielded from view and free from intrusion. Where no space is available that could be made more private on site, employers may fulfill its obligation to provide space through a shared space arrangement with another business. Note that if a nursing employee works off-site at a client's premises, it is still the employer's obligation to ensure that the employee has appropriate space and time for pumping. Will your pump breaks be paid? Employers are not required to provide compensated break time. However, if the employer already provides paid break time and you choose to use that time to express breast milk, you must be compensated for that time just as other employees would be compensated for break time. Additional time used beyond the authorized paid break time could be uncompensated. So for example, if an employer provides a 15-minute paid break and a nursing employee uses that time to express milk and it takes a total of 25 minutes to do so, the 10 minutes in excess of the paid break time does not have to be compensated. Under the FLSA, you must be completely relieved from duty during the break, or the time must be compensated as work time. How do you know if you are eligible to breaks and a private place to pump at work? The break time provision is part of the FLSA, so there must be FLSA coverage. You are covered by the FLSA if you're an employee and you work for an employer that has at least 2 employees and at least $500,000 a year in business, or you work for a hospital, residential, medical, or nursing care facility, school, preschool, or government agency, or you work in a domestic service including home care, or you work in interstate commerce. That is, your work crosses state lines. The definition of interstate commerce is very broad. For example, you make telephone calls to other states, order or receive goods from out-of-state suppliers, send or receive interstate mail or email, handle credit card transactions, or perform accounting or bookkeeping for such activities, or travel to other states. How do you know if you are eligible for breaks and a private place to pump at work? The FLSA break time requirements only apply to employees who are eligible for overtime pay. For example, some salaried managers and office workers, school teachers, over-the-road truckers and helpers, airline employees, and farm workers may not be eligible because they are generally not required to be paid overtime. If employees are not eligible to take breaks to pump under the FLSA, they may be able to take breaks under state laws providing protections to nursing mothers. Even if an employee is not eligible to take breaks to pump at work, an employer cannot retaliate against an employee for asking about their rights. What if you work for a small employer? Even if the employee is covered and eligible for overtime under the FLSA, an employer that employs fewer than 50 employees is not required to provide break time and space under the FLSA if it can demonstrate that providing nursing mothers breaks would pose an undue hardship. It is important to note this is not an automatic exemption for employers with less than 50 employees. The employer must demonstrate undue hardship according to the factors specified in the law. The law defines undue hardship as causing the employer significant difficulty or expense when considered in relation to the size, financial resources, nature, or structure of the employer's business. We expect this to be a stringent standard and one that will be reviewed on a case-by-case basis when asserted by an employer during the course of an investigation. For the purpose of determining the number of employees, all employees, full and part-time employees, are counted, regardless of location or work site. What if you work in a state that has greater protections for nursing mothers? The law explicitly states that the federal requirement of break time for nursing mothers does not preempt a state law that provides greater protections to employees than those provided by the federal law. This means your employer is still has to comply with the state laws that provide greater protections. Some examples of state provisions that go beyond the federal requirements include providing paid break time, providing break time for overtime exempt employees, or providing break time beyond 1 year after the child's birth. State laws vary in terms of protections they provide to nursing mothers. Some state laws specify the number of breaks that must be provided and the length of time. Most state laws focus on the break requirement but do not address the space requirement, whereas the federal law has specific space requirements. What should you tell your employer if you need to take breaks to pump? The department encourages employees to give employers advance notice of their intent to express milk at work in order to facilitate the employer's ability to provide appropriate space. For example, employers may ask expectant mother employees if they intend to take breaks to express milk while at work. Such conversations can inform employees of the right to take such breaks and provide employers with the opportunity to make any necessary arrangements for space before the employee returns to work. Now we are going to hear from Jennifer about additional lactation rights in the workspace.
Thank you, Trini. In addition to your right to a reasonable break time to express milk under the FLSA, you are protected from discrimination based on lactation under the Pregnancy Discrimination Act. Under the Pregnancy Discrimination Act, an employee must have the same freedom to address lactation-related needs that they would have to address other similarly limiting medical conditions. For example, if an employer allows employees to change their schedules or use sick leave for routine doctor appointments and to address non-incapacitating medical conditions, then it must allow lactating employees to change their schedules or use sick leave for lactation-related needs under similar circumstances. Now we will talk a little bit about what to do when your employer is not working with you and you feel as if your rights may have been violated. What should you do if you think you are being discriminated against, harassed, or denied an accommodation? You have a number of options available. If your employer has an internal complaint process, you may decide to avail yourself to that process. If there is no internal complaint process, contact Human Resources or your manager, assuming, of course, that your manager isn't the person you believe is discriminating against you. If you don't feel comfortable filing an internal complaint or you don't feel as if you've been getting help internally, you always have the right to file a charge with the EEOC or the Fair Employment Practice Agency in your local area. We have a very helpful and user-friendly website, www.eeoc.gov, where you can get more information about your federally protected rights. There are specific pages to address pregnancy discrimination, disability discrimination, harassment, and retaliation. To file a complaint with the EEOC, visit www.eeoc.gov. At the top of the page, click on the Employees and Job Applicants tab, and then click on Filing a Charge. What if your employer tries to fire you or punish you for reaching out to the EEOC? The EEOC takes retaliation very seriously, and our laws offer broad protection against retaliation. The laws enforced by the EEOC protect you from being punished, treated differently, harassed, or fired because you or a friend, a family member, or someone else you closely associate with files a job discrimination complaint with the EEOC or reports discrimination to others. These laws protect you whether you are complaining about discrimination directed at you or discrimination directed at others. They protect you from being punished, treated differently, or harassed because you help someone else report job discrimination. We call this your right to be protected from retaliation. When you file a job discrimination complaint with the EEOC or otherwise participate in an EEOC investigation or lawsuit, you are protected against retaliation regardless of the validity or reasonableness of the original allegation of discrimination. This means that it is illegal for your employer to punish you for filing a job discrimination complaint or for participating in an EEOC investigation or lawsuit, even if the employer, the EEOC, or the court determines that discrimination did not occur. This protection applies to anyone who participates in a job discrimination proceeding, including anyone who files an EEOC complaint or lawsuit, talks to the EEOC, or serves as a witness. Although you are protected from retaliation, you are not excused from continuing to perform your job or follow your company's legitimate workplace rules just because you file a complaint with the EEOC or report discrimination to others. Your employer has a right to expect you to continue to fulfill your job responsibilities. Now we're going to hear from Trini about what to do if your FMLA rights have been violated.
Thank you, Jennifer. What should you do if you think your rights to FMLA leave have been violated? The Wage and Hour Division of the U.S. Department of Labor enforces the FMLA. If you believe your rights have been violated, you may file a complaint with the Wage and Hour Division. The division is authorized to investigate valid complaints to determine if a violation of the FMLA has occurred. The division is also authorized to seek relief on behalf of the employee if violations have occurred and may, where appropriate, file a lawsuit. An employee may bring a private civil action against an employer for alleged FMLA violations. Certain limitations apply to suits filed by state employees regarding FMLA leave for their own serious health conditions. An employee is not required to file a complaint with the Wage and Hour Division prior to bringing such action. The filing of a complaint with the Wage and Hour does not stop the running of the 2-year statute of limitations or 3 years in the cases of a willful violation. Where there are FMLA violations, an employer will be liable to the affected employee for damages equal to the amount of wages, salary, or other compensation denied or lost to the employee by reason of the violation. Additionally, damages can include employment benefits. Other remedies include job reinstatement and promotion. What if your employer stops you from taking FMLA leave or fires or punishes you for taking or trying to take FMLA leave? Your employer cannot use the taking of FMLA leave as a negative factor in the employment actions, such as hiring, promotions, or disciplinary actions, nor can FMLA leave be counted under no-fault attendance policies. Employers cannot interfere with or restrain or deny employees' FMLA rights, discriminate or retaliate against an employee for having exercised FMLA rights, discharge or in other way discriminate against an employee because of involvement in any proceeding related to FMLA. Use the taking of FMLA leave as a negative factor in employment actions. What should you do if you think your FLSA break time rights have been violated? The Wage and Hour Division of the U.S. Department of Labor administers and enforces the FLSA, which contains break time for nursing mothers provisions. Similar to potential violations of the FMLA, if you believe your rights have been violated under the FLSA, you may file a complaint with the Wage and Hour Division. The division is also authorized to seek relief on behalf of employee if violations have occurred and may, where appropriate, file a lawsuit. An employee may bring a private civil action against an employer for alleged violations. Action must be taken within 2 years after the last action, which may have been a violation of the FLSA, or within 3 years if the violation was willful. The FLSA prohibits employers from retaliating against workers for exercising their rights, including taking or requesting break time to pump, or filing a complaint that an employer is not providing reasonable break time and a private place to pump. For example, Alicia is a new mother who works at a call center. She uses her lunch break to express breast milk and needs additional time to finish pumping before she is able to return back to work. When she is late, returning from lunch, her boss tells her that she cannot use any more time off for personal stuff. When Alicia asks for another break for pumping later that day, Her boss sends her home for the rest of her shift without pay. Alicia was sent home for attempting to exercise her FLSA rights, which is retaliation by her employer and an FLSA violation. If you are discharged or in any manner discriminated against because you have filed a complaint, you may file a retaliation complaint with the department, or you may file a private right of action under the FLSA for retaliation, seeking reinstatement, lost wages, or other appropriate remedies. Filing a complaint with the Wage and Hour Division. An individual who believes his or her rights have been violated may file a complaint with the Wage and Hour Division. The division is authorized to investigate valid complaints to determine if a violation of FLSA has occurred. You will be directed to the nearest WHD office for assistance. There are WHD offices throughout the country and trained professionals to help you. Filing an FLSA complaint with the Wage Hour Department is similar to filing an FMLA complaint. You may be asked for contact information and for your employment information. Your information is confidential unless you give Wage Hour Department permission to use your name or information. For more information about how to file a complaint with WHD, visit the WHD website, www.wagehour.dol.gov, or you can call 1-866-4US-WAGE. That's 1-866-487-9243. Information that is useful in filing a complaint with the Wage Hour Department includes your name, your address and phone number, how you can be contacted, and what are good times to return a call. The name of the company, where you worked, location of the company. This may be different from where you worked. Phone number of the company, a manager or owner's name, who should be asked to speak to, the type of work you did, how and when were you paid? So, for example, cash or check, were you paid every other Friday? Any additional information that you can provide, such as copies of pay stubs, personal records of hours worked, or other information on the employer's pay and leave practices are also helpful. FMLA information that may be helpful include leave records and copies of leave policies. These pieces of information are not required, but help us develop stronger cases. Yudochi, I will pass it back to you.
Thank you, Trini. Before we take questions, I want to note that if you registered for this event, we will be sending out additional resources, so please be on the lookout for that. We are also going to be sharing in the chat a link to our webpage on the Working Mothers event series. On this page, you will find information about upcoming events and links to helpful resources. Now, we will take questions that we have received through the chat. You can still submit questions using the Q&A feature on the right of your screen. We will try to address as many questions as we can. If your question goes unanswered, please feel free to reach out to our agencies. Our first question will go to Helen. Helen, do employers have to provide time off for doctor's checkups? Should employees use their own PTO?
Thank you, Udochi. And let me also introduce myself. I'm Helen Applewhite with the Wage and Hour Division's Office of Policy, with the division that specifically addresses the Family and Medical Leave Act, FMLA, and the nursing mothers provisions of the FLSA. So to your question, do employers have to provide time off for doctor's checkups? Generally, there's a couple of things to keep in mind with this. With regard to pregnancy and leave related to the pregnancy, leave for prenatal appointments is specifically covered. So employers would have to provide time off under the FMLA for an eligible employee for a prenatal appointment or for the employee's spouse who's providing care for that prenatal appointment as well. In general, for the FMLA, normal regular doctor's appointments like your yearly physical may not be covered, but
appointments related to evaluations or examinations related to a serious health condition would be. So again, prenatal visits and certain visits that are related to the serious health conditions evaluation or examination would be covered. Other normal doctor's appointments would not.
Thank you, Helen. Next question also for Helen. What if I have a job that requires me to drive around, making stops at various locations? Is my employer still obligated to provide both the time and a location to pump?
That's an excellent question, and I've been seeing a lot of excellent questions in coming through. This particular one, the employer is responsible if it's a covered FLSA covered employer, and the employee is requesting break time for pumping. That employer is required to provide both the space and the time for the employee to express milk as often as needed each time the employee needs that. Now, they may do so through making arrangements, for example, with a client company to provide space at the company's location, or if the employee's job includes returning back to the home location at particular points in time, that might work as well. Trini pointed out, communication is an important part of understanding what the employee's needs are related to their lactation needs. So having that conversation and understanding what might work in a specific fact scenario is really important in that regard.
And another question for you, Helen. What are my rights for leave if my employer employs less or fewer than 50 employees?
So under the FMLA, the employer is only a covered employer and only required to provide federal FMLA leave if they have at least 50 employees. It's really important to understand how those 50 employees are counted. It is very similar to with the EEOC presentation as well, the 20 work weeks, calendar work weeks in either the current or preceding calendar year, and it would include all employees, part-time, full-time employees. But if that, that employee count is done correctly and the employer still has fewer than 50 employees, they would not be required to provide FMLA leave. They still may be subject to state laws requiring paid or unpaid leave, and there may still be other, even local laws that could apply as well.
Jennifer, this next question is for you. What if an employer wants to throw a baby shower at work for a pregnant employee?
That's an interesting question. I don't think there's anything in Title VII or the PDA that would prohibit an employer for throwing a baby shower at work. Possibly as a best practice, you might want to consider, the party planners might want to consider talking to the celebrant and saying, are you interested in us having this party? But I don't think there's anything in the law that prohibits it.
Thank you. And then the next two questions I'm going to kick to you, Helen. The first one, do I need a certification to take leave for morning sickness if my company's policy is that a certification is required for all leave requests?
So that's another really interesting question. First, I want to just caution, under the FMLA, you, as an employer, you would have a right for medical certification under certain circumstances, but the FMLA does not permit medical certification to be required for every instance of leave. There are very specific requirements in the regulations about when medical certification may be required. With regard to medical certification for morning sickness, you can request a medical certification for the serious health conditions related to pregnancy, which could include severe morning sickness, for example. That would not
you would not then be able to request a medical certification each time the employee then needed to take leave for that reason. So you would want to examine the requirements around medical certification and make sure that that is aligning, or if it's the employee who's being asked to provide this, they may want to get in contact with one of our offices to and look at the resources that would be provided to understand your rights and protections there.
Thank you. Next question again for Helen. Sorry, let me find the next question. How do unpaid FMLA and paid leave, such as paid time off, vacation, sick leave, work with the states that have their own laws around paid family medical leave? Are those eligible under state law double paid? What are those? Can you provide information about the states that do have those laws, and how do employees know if their state provides paid family medical leave?
Right, thank you, Udochi. A lot to unpack there. Well, first of all, FMLA is an unpaid leave. The federal FMLA is unpaid. However, it runs concurrently with other types of paid leave. The employer is required to designate leave that qualifies as FMLA as federal FMLA leave. However, that leave can run with these other types of paid leave, such as the paid time off, vacation, sick time, to the degree that the employer's policies align with those requirements. Then it can be at the employer's requirement, or if the employee requests for it to run concurrently, it can run at the same time as the unpaid FMLA leave. Now, it's also true that the state paid leave can run concurrently with the FMLA leave as well. You would need to look to the state leave policies with regard to how the pay functions with regard to those specific state paid leave policies. And again, the employer would be required to designate qualifying leave as FMLA leave and run that concurrently with it. And with regard to how employees know if the state provides paid family medical leave or parental leave, there is a website that we can put in the chat that would provide some information about the state paid leave laws. And I believe we also link to that on our website as well. So we can provide that resource for more information about the state paid leave provisions.
Thank you, Helen. Next question I'm going to kick to Jennifer. The question is a pregnant employee who is not eligible for FMLA leave and missing work excessively for morning sickness protected from being fired?
Okay, that's a tricky question. Under Title VII in the PDA, the key would be that the employer treat the pregnant employee the same as non-pregnant employees who are similar in their ability or inability to work. So if the employer provides sporadic leave for temporary disabilities not related to pregnancy, it should do the same for the pregnant employee. The other thing to keep in mind, and we've talked a lot today about some of these intersecting laws and overlapping laws, is under the Americans with Disabilities Act. If the pregnant employee develops a pregnancy-related disability that qualifies as a disability under the ADA, that employee may be entitled to leave as a reasonable accommodation under the ADA. And under the ADA, there is no waiting period. So from the time you are an applicant, you're protected by the ADA, and that continues throughout your employment. So if the individual has developed a disability that might be a pregnancy-related disability covered by the ADA, then leave may be available as an accommodation under the ADA.
Thank you, Jennifer. Next question, I'm going to push back to Helen. Can an employer require a copy of the child's birth certificate?
So the employer has a right to require documentation of the family relationship, which may be just a simple statement from the employee. It's the employee's option of whether to provide such a simple statement or to provide a copy of the medical certification, or they could provide the original, I'm sorry, not medical certification, birth certificate. They could provide the original birth certificate as well if they chose to do so, in which case the employer would be required to return it. But again, it is the employee's option whether to provide the simple statement verifying the family relationship or to provide a copy of that birth certificate.
Another question for you. Can you clarify whether or not the 50 employer threshold applies to state local governments?
Excellent question. Thanks. Whoever's following up on that one. Yes, I should have qualified my earlier answer. For private employers, there is the 50 employee count rule. But state and local government and federal employees are covered without regard to the number of employees employed by the employer. So state and locals particularly, there is no limitation on the number of employees for that employer to be a covered employer. Employees also have to meet their eligibility criteria, though, and that does apply for all employers.
Thank you, Helen. Another question for you. What is considered a good amount of time for a pump break? Do we give 20 minutes, 30 minutes, etc.?
Again, this is another great example of why it's good to have that conversation with the nursing mother to understand what those needs are. The statutory requirement is to provide leave or the break time each time the break is needed. The duration of the break is going to vary depending on a number of different factors. It will vary depending on the amount or the age of the child, for instance. It can vary also depending on the location of the pump room. You know, if it is a long walk for the employee to get to from where the employee's desk is, for instance, that can add to the needed amount of the break time. It's also going to vary depending on access to storage for the milk once it's been pumped. Is there a nearby location sink for the employee to be able to clean the pumping equipment, store the breast milk, and return to their location? So all of those are factors in what amount of time would be needed. And again, we would just encourage that conversation to take place to understand how it is going to apply to the specific mother at that time when the break is needed.
Thank you. Jennifer, the next question is for you. How should an employee respond to an employer who is aware that the employee is likely to become pregnant in the near future and makes comments such as, "You can't get pregnant during this time frame"?
Okay, that's a tricky question. Remember that you are protected from discrimination if you are currently pregnant or if you intend to become pregnant. And if this is a one-off, we would look at this in the totality. We always want to know all the details of a situation. If this is a one-off comment, and depending on how you take it, it's up to you to see if this is offensive to you. If it's a one-time isolated comment, probably not a lot you can do. If it becomes a chronic comment, if it's something where you're constantly being told comments like this, "We've got inventory coming up. You better not get pregnant during inventory. You better not get pregnant during the holidays because that's our busy time." And that could develop into harassment, unlawful harassment based on pregnancy. So the first thing to do is, if it is something where it is comments that come up a lot, talk to the person who's making the comments and say, "Gee, I don't like that. Please stop." And if the comments don't stop, you might want to follow your internal complaint procedure, or you can contact the EEOC. Now, if it's a one-time comment and say it comes from a supervisor, and then lo and behold, you become pregnant during inventory or during the holidays or during whatever time frame the employer expressed was undesirable, and then the employer takes some adverse action because of that, that's a completely different situation, and you should certainly contact the EEOC for more information.
Then another question for you, Jennifer. Do you suggest when some discrimination happens that the employee, if possible, get in contact with or contact their HR manager in writing or via email?
There is no requirement for a complaint, or if you're protesting unlawful discrimination, there's no requirement for that to be made in email. However, if it's more comfortable for you to express yourself in email or make that contact through email, there's no problem in doing that. It's really in terms of what your preference is.
Great. And then this next question, I'm gonna kick to Helen, and feel free to also add, Jennifer, if you have anything. But what is the impact of an employee having part-time status?
So I'll answer that question under both the FMLA and the FLSA nursing mothers provisions. With regard, and I'll start with the nursing mothers provisions. With regard to those provisions, part-time status will be treated in the same way as full-time. The requirement would be looking at whether the employer is covered under the FLSA, and then whether that employee is subject to the overtime requirements, as we talked about earlier. And if so, whether the employee works full-time or part-time would not enter into it. With regard to the FMLA, there are eligibility requirements, and those requirements include that the employee works for a covered employer, works at a site where there's at least 50 employees within 75 miles of the site, and also that the employee works at least 1,250 hours in the 12 months prior to that need for leave, prior to when that leave will commence. So that could include part-time employees, as long as that 1,250 hours is satisfied. And I think in the scenario presented, the employee was working 36 hours per week, and said something about averages time in the 20s. So that sounds like a schedule that varies. What you would do would be look back over the 12-month period prior to the commencement of the leave to determine, does that employee have the required 1,250 hours? And again, a reminder that even if the FMLA does not apply, there could be state or local leave laws that would kick into effect as well. And Jennifer, I don't know if you want to add something to that.
Yes, please. Protection for employees under Title VII or the Pregnancy Discrimination Act, you're protected as an employee regardless of how many hours you work. There's no eligibility requirement in terms of number of hours worked. Employees are protected.
Thank you. Next question. Let me go to both you and Jennifer and Helen again. If an employee quits due to harassment when they're trying to pump in the workplace, can they still file a complaint? Helen, do you want to go first?
Sure, I'll start, and then I think Jennifer probably will want to add to this one as well, because I think there would be protections under both the FLSA and potentially under the PDA or other requirements under EEOC as well. Under the nursing mothers provisions, first of all, we would encourage you to contact our offices if there is a situation where you're being denied your right to pump, or you're being discriminated against, or as the question is put, harassed in the workplace. Certainly it would be very useful to contact our office and see, what support, what protections we might be able to enforce that would prevent it becoming a situation where you feel the need to actually quit due to that. We do treat complaints concerning being denied the ability to pump or having your right to pump interfered with, we do treat those as priority complaints, recognizing that your ability to continue to pump is going to be affected by, what's happening there, and not being allowed to pump can result in you not having the physical ability to continue to pump. So we do treat those as a priority and would encourage that early contact. So with that, if the employee is having their rights interfered with, and that's certainly something that we could look at, or if they're being retaliated with against as a result of the pumping, the request to pump, or the request to have their rights recognized in the workplace, that is certainly something that we could look at. But again, would encourage that early contact when that's happening, if that's a possibility as well. And Jennifer, let you provide your insights as well.
Thank you, Helen. You are protected from any harassment. You're protected from harassment based on pregnancy or a pregnancy-related medical condition, which would include lactation. So if you are subject to harassment based on lactation, you are protected under Title VII and the PDA. The EEOC would not require you to stay in an unsafe or harassing environment. So you are eligible to file a charge even if you do quit, as long as it is within the timely period. What I would recommend is complaining to your employer prior to resigning and give your employer a chance to correct the situation.
I think we have time for just a few more questions. The next one, I'm going to kick to you, Helen. Can you confirm that while an employee is out on leave, can you talk more about benefit coverage while an employee is still on FMLA leave?
Absolutely. So there's two factors on benefits to FMLA leave that's important to keep in mind. First, the FMLA has two main protections. That's the job restoration requirement. You're to be restored to the same or an equivalent job upon return from leave. And the other is the continuation of group health insurance benefits during a period of leave. And you're required to have those benefits maintained in the same way as if leave wasn't happening. So for example, if you have a normal payroll deduction for your share of health insurance costs, that could continue during your period of FMLA leave. If the leave is unpaid, you should make arrangements. The employer should make arrangements with you prior to the leave taking place, ideally, to how that would happen during your period of unpaid leave. But the requirement is still there that group health insurance benefit be maintained during the period of unpaid leave. And then as a part of the benefits discussion, it's really important to also remember that when the employee is restored to their position or a virtually identical position at the end of the period of leave, they're required to be restored to the same level of benefits that they had prior to leave, including group health insurance benefits. So if the employee, for example, was on unpaid leave and was unable to pay for their group health insurance benefits during that unpaid period of leave, the employer's obligation to restore them to that same position includes the same level of health insurance benefits at the time of restoration. So it's really critical that there be some arrangement made to how that's going to take place during a period of unpaid leave so that the employer can meet their obligation for restoration at the end of the period of leave. And other type of benefits as well are included in what you are due at the point that you are restored from your leave, paid or unpaid. You should be restored to the same level of benefits that you had prior to going on leave in all instances.
Thank you, Helen. I think we have time for one more question. Let me see. I can find one very quickly. Helen, can you just speak about the employer responsibilities where an employee is not eligible for FMLA leave?
So the employer is still, if it's a covered employer under the FMLA, you have the 50 employees, but that specific employee is not eligible for the FMLA leave protections. You still have an obligation first to post a general notice to all employees, making sure that they are aware of the rights and their responsibilities under FMLA. You're also required to notify the employee of their eligibility status and to make them aware that they're not an eligible employee. So you would still need to look to check for that eligibility status, ensure that that it hasn't changed over time. For example, if the employee from the previous example who works 36 hours or maybe sometimes only 20 hours, their eligibility status might change from one leave request to another. So it's still the obligation of the employer to make the employee aware of the eligibility status and make the determinations on the leave request. And also, again, keep in mind that other protections could apply, including state, local paid leave, or other types of leave or protections under EEOC as well.
Thank you so much, Helen. Thank you, Jennifer. Thank you, Trini. On behalf, at this point, we're going to wrap up the questions. We're at time. So on behalf of the Wage and Hour Division, the Women's Bureau, and the Equal Employment Opportunity Commission, we want to thank you for joining us. We will make this presentation and slides available, and we hope that you will visit our website to see what upcoming events we have in this series. If you have additional questions, please feel free to reach out to our respective agencies. Thank you for joining us, and this concludes our webinar.